know that the Department of Revenue, through an administrative proceeding, can't make a determination on time sharing or custody. But that's not even an issue for us to address today. The only thing we have to address today is that the 120-day period for service of process did not affect service within 120 days. That there was a default judgment entered in 1999, and we know that the rule requires that a default judgment entered on an improper service is void. And as we continue to go on, so I want to make sure the record is clear, the statutes governing service of process are strictly construed. And that's the Stella versus, I won't butcher the name, but you can go to 76 SO3D 1054,155. Furthermore, I wanted to bring this to your attention as well. If you look in the court's record, you'll see that there was more than one amended complaint. The rule only allows you one amended complaint for cause. After that, you must get permission for the court for leave to amend. And unless there's an objection to what we see, there was more than one amended complaint in this case. And I'll just give you the rule. It's the Florida Rules of Procedure 1.190 states that a party may amend a pleading once as a matter of course at any time before a response to the pleading is served. Otherwise, a party may amend a pleading only by leave of the court or by consent to the party. We know I didn't consent to anything, and that's within the rule. And by the way, in Warner, Warner-Lambert Company versus Patrick, 428 SO2D 718, the Florida DCA, the fourth, in fact, ruled that they reverse and remand the case to the trial court with instructions to dismiss the amended complaint and vacate the default final judgment. And that's actually inside of your inside of the exhibits that I gave you as well. And now, in saying that, as I put inside of the record as well, it's not to say that at some point in time the department could not have amended the complaint, but now because they're not a child anymore, the 36-year-old individual is now beyond the 4-year statute of limitations for when the department could have even brought back the case. We have a dead case. And at any time, the department, through their various attorneys, had every ability and option to have corrected the record. But what they chose to do was disregard well-established law. And because I don't have the original complaint, the court has no basis to show that the proper grounds for establishing jurisdiction are even in the record. You know, before the court can take jurisdiction, it has to say, okay, we have jurisdiction. Did the facts giving rise to the action take place in Florida? I need Mrs. Britt or Mrs. McCarthy. They can answer it, but I don't have any proof in the record that there was an allegation that the facts or events that gave rise to this action took place in North Carolina, Florida, or Texas, or anywhere else. There's absolutely no evidence in the record whatsoever to have supported this. And I know I'm not the only person who suffered because of the egregiousness of the Department of Revenue. And as I told you before, I think it's motivated by, more than anything else, the hue of people's skin. And of course, if you're poor, you're just the same as being black in this state for sure. But these disregardings of the law, despite what you may do, whatever you do today is not going to change anything. My position is clear and the law is clear. I'm just a little perplexed as to why not only many attorneys for the Department of Revenue have chosen not to do the right thing, but the chief judge who hires hearing officers and even the attorney general's office who hires attorneys has done nothing at all to correct this problem. I know it's pervasive. Nonetheless, there's no grounds play it anywhere that show that Florida court had grounds for jurisdiction. Now, Failure to adequately allege the relevant jurisdictional basis does void any attempted service, even under long-arm statute. So Ms. McCarthy did make a statement in open court, or I mean in his hearings, not court, in this hearing, that this petition or this complaint exists. I'd like to see the complaint. In 1995, well-established law required the service of process of an initial complaint and summons within 120 days of filing. The 120-day limit to effect service of process, which was established by the Federal Rule of Civil Procedure 4J, we know that's called federalism, is to be strictly applied. Now, and if service of the summons and the complaint is not made in time, and the plaintiff fails to demonstrate good cause for the delay, the court must dismiss the action as to the unserved defendant, which would have been me. And that's Morales versus Ferry Rand, and that's 578 SO.2D 1143, 1145. And we don't have to continue to beat this dead horse, but I'm going to. It doesn't show successful service of process within the first 120 days of the DOR or Minister McIntosh filing his complaint summons. And by the way, the docket doesn't show any effort whatsoever of good cause for not serving it within the 120 days. In 1995, when this case was initiated, the law mandated that the court dismiss the action if it wasn't served within the 120 days, and there's no showing of good cause. Go to Hodges versus Knoll, that's 675 SO2D 248, and it says a trial court may not exercise its discretion to refuse to dismiss a case under rule that's 1.070I unless the record evidence of efforts made at the service during the 120-day period, which would support a finding of good cause under the rule, that still would not excuse you showing the court good cause. It doesn't, and by the way, it shows that the DOR did amend its complaint twice without leave of court, once on February 9th, 1998, and again on September 10th, 1998. The rule for amending a complaint under the rule I've already mentioned earlier, which is Civil Procedure 1.190A, only allows one amendment without leave of court. You can see Fusiller versus Markov, that's 676 SO2D 1053 and 1054. And as I stated before, a party may amend the pleading once as a matter of course at any time before response to pleading is served. Otherwise, a party may amend the pleading only by leave of the court or by consent of the parties. You already gone to that.